Lindsay, good morning. And the whole issue of how you need to change legislation in order to impeach a public protector is going to be taking center stage then from Parliament today.
Good morning, Dan. Yes, that certainly is the case, as you've pointed out. Not the first time opposition parties are putting this matter before Parliament, but it is not as easy as one might think it is. It's been the want of Parliament to date just to establish ad hoc committees to hold inquiries and to deal with matters like that. But as you've pointed out, it's a little bit more complicated than that, and rules have to be set out. Parliament has never dealt with a matter like this before. Looking to determine the fitness to hold office of somebody who heads a Chapter 9 institution, ultimately with the view of removing that incumbent. But with me I have the DA's Chief Whip, John Steenhuisen, who has brought the party's second attempt to question the Public Protector's fitness to hold office. John, good morning. Thank you for joining us. As we've pointed out, not the first time you're bringing this. How did the party envision dealing with this case in the light of the fact that there are no rules to deal with such a matter?
Well, as I said, this is new territory, and I think that what happened with the Jiba and Mrebi matter in the last week has made us live to the fact that it is probably safer to ensure that we've got rules in place to deal with this particular situation. As you've said, it's uncharted territory. Parliament hasn't dealt with this type of inquiry before, and so it's important that some rules are codified. And this is particularly important given the litigious nature of Advocate Mkhwebane and the fact that she has a track record of spending vast sums of public money on frivolous court cases, that it's probably better to ensure we have an inviolable process in place that can then, once Parliament embarks upon it, is incapable of being interdicted or stopped, because it is fair, open, transparent, and is in terms of Section 57 of the Constitution, which empowers Parliament to make such rules.
The Rules Committee last had to make rules to deal with the impeachment of a president. It could take some time for them to do that. How does the party envision, what will you be asking the committee this morning as to how to take this matter forward?
Well, obviously what this committee needs to do is write back to the Speaker and say, yes, we are prepared to conduct such an inquiry. However, we would require a process to do so, and that is in the purview of the Rules Committee. The Speaker is the chairman of the Rules Committee and must then convene it. Once this committee has made that recommendation today, if that is the recommendation, we will immediately write to the Speaker and ask for her to convene the Rules Committee next week so that we can begin work. What Parliament can't do is sit on its hands. This is an important matter, and I want to be very, very clear that Parliament is well within its rights to conduct such an inquiry. We just believe, given these circumstances and the nature of Mrs. Mkhwebane and her confrontational approach that she's adopted to Parliament, that it's probably better that we have rules in place so that we can ensure that when we do go for her and we do take action, that she's not going to be able to wiggle out of it with some loophole, but that there were no rules in place.
Once these rules are established, is it then your want that there is a full inquiry conducted, or is there enough, in your view, enough evidence already on the table that speaks to her fitness to hold office?
Well, we've been very clear from the beginning. We don't believe she's a fit and proper person, and sadly we've been proven right by now this devastating constitutional court judgment, which basically found her to have acted dishonestly. That's a clear grounds of misconduct. We believe there's a clear, open and shut case against her, but that being said, there has to be a fair process. She has to have an opportunity to put her side of the story, to explain why she's made these judgments, how she believes she's going to be able to sustain her credibility, and the credibility, most importantly, of the office of the Chapter 9 institution, the Office of the Public Protector, going forward, given the devastation that she's wrought on the credibility of that office. So I think that this is the safer way to go, and it will ensure as well that there's a process that she is not going to be able to just wiggle out of or find some loophole in later. So, although it looks like it may be a slight delay, it is a slight delay, but nonetheless, justice will be done, she will have her day, and she will be held accountable, as Parliament must do.
Dan, so that's the DA's explanation of how they would like to see this matter proceed. I should also point out that the Justice Committee today also having to deal with the matter of a Deputy Public Protector. Kevin Malunga's term comes to an end in December, and so there are quite urgent matters for this committee to deal with as regards the Public Protector's office, including finding a new deputy for Busisiwe Mkhwebane.
Thank you very much, Lindsay Dentlinger, in Parliament for us.